We will now pass the floor to Dr. Hugo Moredo dos Santos, who is a partner of the finance team at law firm Vieira de Almeida and Associados, and also a leading expert in fintech-related matters. And he will make his presentation on the licensing principle in capital markets law.
First of all, good morning. It is a great pleasure to be here. It's always a great pleasure to return to a place where I've been very happy. This is the place where I graduated. This is the place where I obtained my master in laws. And it is really an honor to take part of this panel. I would start by thanking Professor Dário Moura Vicente, Professor Diogo Pereira Duarte, Professora Catarina Granadeiro, for the organization and the invitation that has been extended to me. Congratulate also my the panel members, Francisco and Nuno, and of course congratulate the Lisbon School of Law and the EBI for this initiative, which is a timely initiative, very important, and allows us to discuss a very hot topic these days. My presentation will be about fintech regulation and licensing principle in capital markets law. And when I first thought how to start this presentation, I thought it would be useful first to discuss what is capital markets and what is the function of capital markets. Because knowing what is capital markets and what is its function will certainly allow us to better understand why there is a licensing principle. And I will elaborate a bit more on that later on, why there is a licensing principle in capital markets. As we all know, capital markets is an alternative to the traditional banking market. We heard Professor Mendes Correia speaking about the licensing principle in banking market, in banking law, and we understand that banks play a traditional and very relevant role in financing the economy. But that's not the only way things work. And capital markets is precisely that alternative market that allows sovereign entities, autonomous regions, municipalities, banks, corporates to obtain funding. So this is a highly regulated market for obvious reasons, because the potential funder is not a credit institution. The potential funder may also be any one of us in this room. So this, of course, raises concerns that shape how regulation is made, because, of course, it is critical for the overall system, for the functioning of the economy, of the markets, that things happen as they should happen. And there is a very wide and detailed regulation in respect of capital markets, as there is a very wide and detailed supervision by the relevant authorities in capital markets. And if we take a close look to the recitals, and I selected just a few randomly, the recitals of key pieces of legislation in capital markets, and I quote here the Takeover Directive, which actually is not a capital markets directive, but a companies law directive, but it plays a very relevant role in capital markets, or the Market Abuse Regulation, or the Prospectus Regulation, Transparency Directive, or the PRIPS Regulation. You can see in all these pieces of regulation a common concern, and that concern is investor protection. Enhancing investor protection means sharing information which is of good quality, sharing information timely that allows markets to function regularly, efficiently, because that is the only way people, like any one of us, may play a role in capital markets, because it feels safe, it feels credible, it feels, it induces trust. If that fails to be the case, then this alternative means of companies, banks, sovereign entities, etc., raising funds will not be open. And before I touch specifically on the licensing principle, I would like just to deviate a bit, because when we think about capital markets, and I mentioned that this is a highly regulated market, I think we should also consider those transactions which need to be approved, and they need to be approved for a certain reason. If we take a look at what happens generally, we come easily to the conclusion that the creation and the trading of financial instruments, and it would be a very interesting debate to know whether or not new forms of assets like crypto assets, tokens, should or should not be qualified as financial instruments, are not subject to restrictions. Everyone can sell or buy shares, bonds, etc. However, if we take a closer look, we easily come to the conclusion that when we touch a wider range of investors, when we reach the trading of securities in a regulated market, then the regulator steps in. And the regulator steps in not to provide a license to the operators, but to take a closer look at the transaction features, to make sure that that transaction, what is being proposed to the public in general, what is expected to be traded in a regulated market, actually meets the standards. And this is perfectly obvious in public offerings of securities and advertisings. That's also obvious in takeovers. Even when we consider a voluntary takeover, so something that someone decides to do out of its own initiative, there is regulatory intervention. It is not a process that anyone can do without considering the process the law clearly defines for such purpose. And that requires interacting with the regulator. That, to a certain extent, means being subject to a sort of licensing. And we can say the same in respect of BRIPs. I think we can say the same in respect of many transactions. And these are merely examples. And if we take a look at what the prospectus regulation says in this respect, we come to a very clear conclusion that licensing, which in this case means passing the transaction through the scrutiny of a regulator, is quite relevant. Because no one, and I'm speaking specifically about public offerings, of course there are exemptions, but in general, no one can do a public offering of securities without first obtaining the approval of the relevant prospectus. And let's see in which circumstances that road cannot be followed. And the regulation is very clear. The draft prospectus, so the key document, the document that makes the connection between the issuer and the investors, does not meet the standards for completeness, comprehensibility, and consistency. So the minimum standards, the level playing field that a given entity should reach in order to be comparable with other entities is not met. And in that specific case, the transaction cannot move forward. Again, we're not talking about licensing entities. Well, but to a certain extent we are. And if we take a look, if we take a look to what supervision means, we reach what Professor Christos Grosso said at the beginning. This is the very first step. When we look to licensing, we first confirm, and when I say we, I mean the regulator first confirms that the relevant entity meets all requisites that are required in order to operate. It can open the door and start business. Without making this confirmation, without making sure that everything that needs to be there is there, then activities cannot start. Because the public interest nature of capital markets leads to certain of its players being subject to this scrutiny. And of course, this is a natural step to organize supervision, because supervision is not a one moment only action, it is a continuous action, as we will see. And the principles that guide CMVM in this respect, and I'm sure that in the next panel this issue will also be discussed, as capital markets regulator, we can see, again, the investor protection and the efficiency and regular functioning of financial instruments markets being one of the key drivers. This is a major concern. We know that when things do not happen as they should, the investors are not there. They will go away. And that will be extremely detrimental to the functioning of capital markets. As I said, and this is merely an example of certain market players, we see a sort of licensing when it comes, for instance, to entities such as investors or issuers. Well, you may argue, well, investors are not subject to licensing. Well, yes and no. None of us is subject to licensing, of course. Any one of us may buy or sell shares or bonds or whatever. But if we consider a qualified investor, if we consider banks, as was the subject of the first speech, then we come to the conclusion that banks are not authorized as investors, but they are authorized, they are licensed as such in order also to become qualified investors. When we consider issuers, for instance, any entity can start its business. Yes, that's true, but when it comes to touching capital markets, when it comes to opening the door to public in general, to public investment, then we come across with the definition of public offer, as I mentioned. And in that scenario, even though there is no scrutiny about the entity itself, about its merits, about what could be its business, there is, of course, an assessment as to the risks it poses, about the activities it develops, and the transaction cannot see the daylight without the prospectus being approved, so without the regulator controlling the information that is being provided. But then we have a different layer of supervision. Supervision that covers not only the aspects that I mentioned, but goes one step further, as I will explain. And this covers, of course, investment companies, which is, side by side with credit institutions, a set of financial intermediaries that are subject to the licensing principle. This is a non-exhaustive list. I can mention here management companies, Professor Christos Grossos mentioned credit rating agencies, which, as we all know, were totally unregulated until 2009. It was in the aftermath of the financial crisis that they started to be regulated, because they perform a very relevant role. They influence how investors look at financial instruments. And when we see the proposal for a green bond regulation being discussed, and we see that maybe 9/10 of the articles are dedicated to the entities that externally certify the bonds, and finally issue a second-party opinion, we come to the conclusion that these entities, because of the influence they have in the capital markets, need to be licensed. And how can we explain this? Well, it's very simple. Supervision and the licensing it requires is, of course, one of the key focus of CMVM, of the Portuguese regulator. So this means following up the activities of entities subject to supervision, being closely monitoring laws and regulations, and of course, granting approvals. That's exactly the point I wanted to make when I mentioned that not only market participants are subject to licensing, but also transactions are subject to authorization, to prior scrutiny by the regulator, which of course will continue to investigate breaches and apply fines whenever necessary. But then we can take one step further and go to prudential supervision. In this case, we're not just discussing the general supervision. We're taking one step further, because there is a very high level of adverse impact if any of these entities breach. So it is relevant for entities such as management companies. Either they manage the securitization funds, or they manage venture capital funds, or they manage other sort of collective investment schemes. They need to have a certain level of solvability and liquidity that ensure that they are not expected to fail. The same goes to avoiding systemic risks, because we know, and again, the financial crisis showed us that the occurrence of a given event in a member state may have a domino effect in all the member states. And in a cross-border world where transactions happen in more than one place, it is necessary to make sure that we do not let one player contaminate the system and jeopardize the confidence of investors. And again, it is necessary to look at those that take decisions. Those that take decisions by appointing the managers and the auditors, and those that form part of members of board of directors or board of auditors. These roles are not free seats. These roles need to be monitored to make sure that the entities and individuals sitting at the boards of directors, at the boards of auditors, do comply with what is necessary to make sure the activities are carried out in a prudent and sound manner. And of course, this means that prudential rules go much further and require the entities I mentioned to take a much deeper approach to their activity. Of course, there is prior approval from the Portuguese Securities Market Commission as supervisory authority, assessing what needs to be achieved at day one, at inception, like the minimum share capital, but also those topics that need to be assessed on a regular basis, such as the minimum level of own funds, or the holders of qualifying holdings, or members of the boards, as well as define what are restricted transactions, because they may put at risk what is the activity of the relevant entity. Again, disclosure and information plays a very relevant role, and there is, of course, a very high level of scrutiny in respect of everything that is to be disclosed by the entity subject to prudential supervision. Closing remark to say that in a changing world, there are things that do not change. And going back to the beginning of this presentation, I recall that I mentioned investors' protection as a key driver for the licensing principle, as a key driver for the need to obtain approval for certain transactions due to their relevance, due to their impact. If we take a close look to the Capital Markets Union 2020 Action Plan, and we take a look at each of the measures that form part of the the three key objectives that are presented here, you can see in each one of them that investors' protection continues to be, and I will say will continue to be, a cornerstone of the regulation in capital markets, and also a key reason for the licensing principle to continue to make sense in order to protect the market, in order to make sure that this market continues to be an alternative for the economy to grow and for players to achieve an alternative to the traditional banking market. It has been a pleasure being here with you today, and thank you very much for your attention.